Hello, welcome back to the people who are joining us who were here on the session last week or have watched the video since, which has been great numbers. All the people who are joining us for the first time this week as well. This is the first time you're seeing us. So just a bit of background about these sessions. My name's Paul Holcroft. I'm from a business called Croner Group Limited, and we specialise in HR, health and safety, employment law. The purpose of doing these sessions was to give some practical guidance to businesses about the job retention scheme, about what's changing, about the new things that are going to be coming up. So we've got a bit of a format for how we're going to do the session today. We'll cover this in three parts. The first part is I'll go through some of the questions I didn't get time to deal with on the last session, or some of the questions which have been sent in since then. Then we'll go into an open Q&A session. And then at the end, I want to talk a bit about what's coming up next. Now, we're at an exciting part here because everything's going to change next week. The Prime Minister's going to come out and give an announcement on Sunday, and he's going to announce what the plan is going to be, the staged return for businesses getting back to work. Also, we're expecting an announcement from the Chancellor at some point next week. So when we come on to next Wednesday's session, and we do this again next Wednesday, that will be talking about the details of what's been discussed by the Prime Minister on Sunday. And if the Chancellor comes out and speaks before Wednesday, I'll cover that as well. But we'll get some good indications from what the Prime Minister says on Sunday. So when it comes to asking any question, feel free to just pop any question you want, put anything in there. Last week, we were under so many questions that I didn't get a chance to get round to answering everything. I'll get a chance to answer as many as I can, and the questions I feel are most relevant to everybody that everyone's going to benefit from. But if you put your questions in there, I'll do what I'm going to do at the beginning of this session, and I'll go back over the questions because a lot of them were very similar. I'm going to kind of try and bulk them together to one area. So if I just go through that first, we go through some of the questions we didn't get a chance to get to last week. Then we'll do an open live Q&A. And then I want to talk a little bit about what you as a business should be expecting on Sunday and should be expecting to come out from the Chancellor, and what you need to be thinking about as a business and getting ready for that what's going to be a new way of working and a big change. So first of all, if we just go to the questions that we had from last time, and I've got 4 of these questions that I broke out. These were kind of the 4 key categories of how questions came in. The first one was asking about what employees can do while they're furloughed. So I know a lot of employees are wondering about this. So under the job retention scheme, it's very clear that an employee can't work. So work is defined as anything that generates revenue for a business or provides services for a business. I think that the part where we talk about generating revenue from a business appears on the face of it more straightforward. They've actually generated a sale, they've generated income for that business. I think that one seems a bit more straightforward. The one where we're getting a lot of questions, and I'm speaking to a lot of different clients about their exact different situations, and that's dependent on their business, is what is providing service. And people have given a couple of examples of questions they've got, and I'm going to give my view on them, and hopefully that'll help you in your business. And as I said, feel free to ask any more questions you want. Ask me to have a look at another example if you want me to as well. But the 2 examples that got sent through were, can employees on furlough attend team meetings? And can we call and ask employees who are on furlough about their job? Because they might be the only person who knows how to do a certain area of the business. Something comes up, you don't need them for that whole period, but you do want to ask them a specific question about their job and something that they know they've got a very particular knowledge of. Is that something that we can go and do? And does that jeopardize our ability to claim under the job retention scheme? So I'll go through team meetings first, and I'll give my view on team meetings. I think the team meetings is a difficult one. I think team meetings is one that you need to be very clear about what's covered at that meeting. But I would struggle to see how in some part the employee would not bleed over into providing some sort of service for the business in there. They give a view on how something should be done, a change to something. It's very different about what the agenda is at that meeting. I think training is something different. We can have employees in on training, that's very clear. Employees can come in for training, it relates to their role. Just a thing on that is that the training part of it attracts a national minimum wage, whereas the normal 80% furlough doesn't. That won't have an effect on most employees, but the ones who are at the bottom earnings level, they have to be paid national minimum wage for the training. So you may have to top that up as an employer. So training, we think training is okay. Training is fine. It actually encourages training under the government guidance. But a team meeting is something different. And that depends on what is said at that team meeting, what the employee does. We don't have any further guidance on this. So the best advice is to say, no, they don't attend a team meeting, because you've got a risk of them overflowing and spilling over into providing service for the business. The same thing applies to the other point that somebody asked about, which is what about calling them up and asking them about a particular part of their job? Well, calling them up and asking them about a particular part of their job, I would say, is likely to be provision of service. If they're saying, oh, well, I would do this and I would do this and I would say that we go at it this way, is that not something you would employ somebody to do? Is that not something that somebody would work under a contract to provide? Is that therefore by definition not work? Now, while we don't have any clear guidelines on this, I would give advice to say that you don't want to be the test case for this. And the best thing to do is to leave employees while they're furloughed, to let them relax, to take that time away from work, to keep them updated on what's happening. We think that's good practice to let them know what's happening in the business. But when you start asking them questions and asking for information, asking them to attend meetings where they have to interact in that meeting, you are running the risk of that becoming work and therefore outside of the job retention scheme. I hope that answers that within that context. Okay, so second question that we got from a few people, and I'll cover this at the end as well when I come on to what I think is going to happen next, is layoff, is how this situation is going to evolve into short-time working and how it's going to evolve into layoff, potentially redundancy situations as well. So the question that we had was, can I change employee status from furlough to laid off? So first of all, can you change an employee's status once they're on furlough? Yes, you can. Furlough needs agreement by both parties. So if at any point the employer decides, well, I no longer want to give my agreement to furlough, I want that furlough period to end, then that's the end of the furlough period. You then go into a question of what happens next with that employee. You've got a contract with them, dependent on what the contract says, whether they're on variable hours, flexible hours. But if you've got a contract where they get remunerated to provide work for set hours, you have to provide them with a salary under that contract, whether you've got the work or not. So what position are you in then? Well, if you've got a cessation of work, it's gone away, you've got a reduction of work, you could have a redundancy situation. And that's where we're considering a layoff as well, placing an employee on a period of layoff or a period of short-time working as well, where they're working reduced hours, less than half their hours that they would work in that week. And that might be something that we're looking at getting announced on Sunday, something that I think is going to be likely a consideration for employers in the new world as we come back. But I'll cover that in more detail then. But just for layoff and for short-time working, yes, you can do that, but you need a clause to do that. And always think about this throughout everything that we're talking about, everything with the job retention scheme. The job retention scheme does not supersede employment law. It doesn't wipe employment law away. Employment law still sits there as it ever did before. And if you're going to ask an employee to reduce their hours of work, can you just do that? Can you just say to an employee, sorry, I'm just reducing your hours of work from 30 a week to 20 a week? The answer is, unless you've got a clause which allows you to vary, then no, you can't. You need to go into an agreement with that employee to vary that clause. And you can vary any clause of a contract with an employee as long as both parties agree to it, and as long as it doesn't go below any statutory minimum. So say like 5.6 weeks annual leave for the year, national minimum wage, national living wage, working time regulations or work hours, things like that. As long as it doesn't break the law in doing it, yes, you can come to an agreement with an employee on shorter hours. There's a process for doing that, and sometimes that's outlined in the contract. Sometimes you have to go into a collective consultation process as well. But in short, yes, you can move an employee from furlough to layoff as long as you've got the correct clause or you agree that with an employee. The third question that we had, and quite a few people asked this, we've got quite a few requests about the same question. I think people are lacking clarity on this point of rotation. So how can I rotate staff on furlough, and how long do they need to be off for? So simple answer to that is yes, you can rotate staff who are on furlough. And some businesses might think this is quite a good idea. If you've got a team of 10 people and you need to furlough 5 of them, you've got work for 5. Do you want those 5 people to be off for what could be up to 4 months and then returning back to work? Or do you want to rotate them, and everybody has periods of time off work? People are coming in, they might feel like they want to be furloughed, they might feel like they don't want to be furloughed, depending on the business, dependent on sometimes what's being paid, whether that's 80% or 100%. But yes, employers have that option. But to claim under the job retention scheme for anybody who is furloughed, they need to be furloughed for a minimum period of 3 weeks. I had some confusion before that this needs to be in 3-week blocks. So either 3 weeks or 6 weeks or 9 weeks. It doesn't. It just needs to be for a minimum period of 3 weeks, 21 consecutive days. And think about that as well for somebody who works less hours a week or less days a week. Do we need to get 21 days for someone who works a couple of days a week? Well, no, the guidance doesn't identify that. So it could be that if somebody works 1 day a week, then 3 weeks for them could mean actually 3 working days that they didn't work for, but still a 3-week window, a 3 calendar week period. So yes, you can rotate staff, but you have to go through the re-furlough process all the time. So you would say to them, okay, you're on furlough. I'd like you to come back to work. I'm ending that furlough period. I want you to come back to work. And you've got to go through the full return to work process. What's going to happen with them when they come back to work? That's the stuff I'm going to really look at the end about how we get this workforce back. But then you would go into another negotiation with your other employee who you're going to put onto furlough. So we need to agree with them. And we need to make sure as well that we hit the 3-stage test that we need to do for furlough. So 1, as I said before, with people doing team meetings and things like that, they need to stop working. 2, it needs to be for a minimum period of 3 weeks. And the third thing, which is quite straightforward, it needs to be in reaction to the coronavirus. So simply what you need to do with your employees is gain agreement. There's a bit of contradiction between the Treasury direction and the government guidance about how we get agreement, but getting that in writing from the employees would be the safest bet. And then you also need to think about, like I said before, don't think that this completely wipes away employment law, though. If you're thinking of paying your employees 80% of their salary, well, then you need to agree with them that you're going to pay 80% of their salary for a set period. And I would do it at the same time you're agreeing with them to go on furlough and get them to agree to that in writing. Because if you just get them to agree to go on furlough, but you pay them 80%, well, that's fine for you to be claiming under the job retention scheme. That's going to be seen as a potential a breach of contract for the employee, maybe even a fundamental breach if they've got 2 years service, thinking about maybe a constructive dismissal claim there as well. So get those 2 things agreed. Get the new employee to agree to go on furlough, get them to agree to take the reduced pay. Now, if you're paying 100% pay, you don't need that agreement. And the last one we had that was pulled together from the questions we had before was, what if an employee comes to the end of their probationary period and it's not worked out? Do I need to extend probation until lockdown is over to avoid them having financial problems? So we're getting asked this question quite a bit. Does everything go on pause for this window? Now, does it mean that we can't do anything as a business? We can't remove an employee who's not working. We can't hire a new employee. How does it work? And as I said before, go back to thinking this is not superseded employment law. Employment law sits there as it did before. If you've got an employee who's had a probationary period which ends within the current job retention scheme period and they're on furlough, then yes, if it's not worked out, yes, you can terminate their employment. Yes, you can fail their probation. Think about that in the rules of all employment law, though. Think about that they might not have the requisite 2 years of service to claim unfair dismissal, but is there something else here? Is there sickness? Is there pregnancy? Is there some other protected characteristic which might have affected it? Is there a disability issue here? Has you given them enough time within that period, if they've been on furlough for a window, to be able to evidence that they can do the role? Have we made reasonable adjustments? If it falls into one of those categories, there are always things to bear in mind as well when you're talking about this. And that's obviously dependent upon the situation to do with that employee. But in short, an answer to that is yes, if you have a probationary period which ends in that window, yes, we can move through normal processes, we can terminate an employee, but we have to follow employment law as sat there before we went through this process. So they were the questions that we had sent in, and if it's okay, I'll just move over now and we'll move into a Q&A session. Now, if you want to ask me anything which is a bit more specific or a bit more of an advancement on some of the points that I've raised there as well, that's fine. but just feel free to put anything in and I'll work my way through the questions. So, Linda, I've got a question from you to say, if you close for furlough but need to bring people back in to do a job for 2 days, are you then breaking furlough completely? Can you then start to reclaim after the 2 days? This is a really common question that we're getting quite a lot. My business isn't open yet, but I do have enough work for somebody to come in and do 1 day or do 2 days, but I certainly don't need them back for the full 5 days a week they were working before. Does that mean I can still claim for them for maybe the 4 days, or in this case, maybe the 3 days under the job retention scheme? The answer to that is no, you can't. If they're on furlough, they're on furlough. They can't work 1 hour. They do not work in that period. And if they do come in and work 2 days, you break, as you say, you kind of break the chain on furlough, and then the 3-week period would start again. So if they're coming in 2 days a week, in practice, you would never be able to claim for them under the job retention scheme. One of the things I would think about in that situation would be maybe rotation of staff. So maybe rather than somebody working 2 days, another member of staff working 4 days or 5 days, and then if there's different people who do the same role, rotating them. But as long as they work for a 3-week block every time, we're safe to claim for that under the job retention scheme. Okay. Question from James. Hi, Paul. If an employee cheaply transfers to me at the beginning of April, can I furlough them? Okay. So think about this again. As I said before, normal employment law rules apply. I'm going to keep repeating this point because this is what people are getting confused by when it comes to the job retention scheme. They feel like this has superseded it. So do cheapy rules apply? Can an employee transfer between businesses? Yes, they can. And if you've got an employee who cheaply transferred to you at the beginning of April, can you furlough them? Yes, you can. They moved over. They've been transferred. They were employed for you at the beginning of April. That's fine to place them on a period of furlough, as long as, just going back into that, as long as this is a cheapy transfer, as long as all the relevant work was done in it, and we're happy it was a cheapy transfer and they're fully employed by you. But in theory, yes, an employee is cheapy transferred, can come over. Okay, I think this is a good question to jump to, because this question ties into something that I've been going on about at the beginning, talking about work. Joe's asked, if a director of a business has been furloughed, what can they do? Can they administer the furlough scheme? Can they be updating the website, etc., etc.? Okay. So this is a question we're getting a lot as well. So I'm a business owner, but I'm also an employee, and I have people who work for me, and I'm furloughed as a director. I'm furloughed. Is that fine? Can a director be furloughed and claim under the job retention scheme? Yes, a director can be furloughed and a director can claim under the job retention scheme. But go back to thinking about the 3-stage test. Always come back to that. The second and third stage being minimum period of 3 weeks and in reaction to coronavirus. But what's relevant to you here, Joe, is the first stage of that test. What's the definition of work? Now, I spoke before about team meetings. I spoke before about calling an employee up and asking them to give you some service and help them with a role. Does that classify as work? Well, this is even more so when it comes to a director. And with a small business, you think, well, is it possible for a director to be furloughed? Because someone has to administer the scheme, someone has to do the HR. Who's just going to leave the business and not update the website, not do anything, not do any work for the business whatsoever? Well, the issue is with that is that would lead you with a situation where, by definition, there's a good chance that the director is going to be working. Now, I've got some guidance here. So we've got the Treasury Direction, and the Treasury Direction covers off. That's the piece of law that we have, which covers off what we've been talking about. We've got government guidance as well, and what this says in respect of a director. So it does give an exemption. You've got the classification of work within there, seesaw work in relation to the employment, but then we've got a bit of an exemption, a bit of a rule for directors. So this says, paragraph 6.6, it says, work undertaken by a director of a company to fulfil a duty or other obligations arising by or under an act of parliament relating to the filing of company accounts or provision of other information relating to the administration of the director's company must be disregarded for the purposes of 6.1a. Now, 6.1a is work. So it's saying that these things are disregarded for the purposes of work. So a director has obligations under the Companies Act. But it's very clear here. It gives us two situations which would give us an exemption from the classification of work. One is the filing of company accounts, and two is provision of other information relating to the administration of a director's company. Now, on strict interpretation of that direction, I would say that administering the furlough scheme, as in doing the internal HR, working with employees, writing to them, is providing a service. I would say updating the website is providing a service. If any revenue is generated from that as well, and we bring in new business off the back of what's done in that period, that's something which could also go into the first part of generating revenue. So the likelihood on that, as far as it stands now, we may get further guidance on this. This may be expanded on, but as it stands now, I would say that I would likely say that that would be work, and therefore would mean that you couldn't claim under the job retention scheme. But bear in mind that this still hasn't been clarified at this exact point of what would happen in these situations. This clarification will go on for months and months as we get more and more situations. Okay, just let me have a look here. Okay, Julie, I think I'll jump to your question here, because I think this relates back to a point that I've just made. And this is a thing that a lot of people are asking. Can you clarify what training they can do on furlough, please? Government guidance is clear on this. They actually encourage employees to do training, and the training relates to their role. So I think you're fine if, under that government guidance, that an employee dials into a meeting, an employee watches some training or undertakes training that they're asked to do by their employer. That's encouraged. So I think that training will be fine. It's just if what that training forms part of, if that training is part of a team meeting, if that training is part of them required to do something and provide a service to their employer, something that would be expected to be remunerated for, then you're moving over to the realm of that being classification of providing service. So I think in general terms, training of employees is fine. Again, I'll reiterate, think about the national minimum wage point on that, but that might not be an issue for you. But I think training in theory is fine. It's just as long as that training doesn't go as far as to then require them to have to do something or provide something that would further the business, and in essence, by definition, provide services as well. So, question from Lewis: can an employee on unpaid leave be furloughed? So, unpaid leave is a good question. I don't think this is something that we've actually discussed yet. But an employee on unpaid leave can be furloughed. But there's a rule to this. So if the unpaid leave started before the 28th of February this year, then they have to finish their period of unpaid leave before they can move over to furlough. If the period of unpaid leave started after the 28th of February, then yes, we can move them from unpaid leave to furlough. Quite a straightforward answer. I hope that helps on unpaid leave. Okay, question from Lindsay. Someone's liked your question as well, so it must be another person must want me to answer this one. So how much notice do we need to give to staff to bring them back to work and off furlough? As far as it goes for the direction and from the government guidance, there is no clarification on this point. I think it's just what is reasonable. And we've spoke to clients who have brought people back the same day. We spoke to them in the morning and said, we've got a massive increase in demand. We would like you to come back this afternoon. We've had other businesses who've said, can you come back tomorrow? I think it's quite reasonable to say, can you come back the following day? The employees should be in a position where they're on furlough, where they're ready to work if work is required. It's not that they would be on a period furlough and then into kind of a notice period at the end of that furlough before any return was required. So there is no reasonableness about this. I would discuss this with the employee. I think that's the best practice, and see if they're comfortable to do it. But I think I would be clear if the employee said, "Well, I think I'd probably like another 2 weeks, and then I'll come back." I would disagree with that, because you need agreement from both parties to furlough, and you can end your agreement that day and say, "I want you back tomorrow," because they should be available. They should be available to work. Okay, a bit of an expansion on the probationary question here. This question's from Jane. So the probation question, can you extend in writing if they're temporarily redeployed into another role due to COVID-19? Yes. Yeah, you can extend probation, that's fine. Always think about all the employment law that sits behind it. Always think about probation as usually a short service employee, so somebody who's got less than 2 years service, which means they don't yet have the right to bring a claim of ordinary unfair dismissal. They can bring a claim for one of the automatic unfair dismissals or a discrimination claim, but they can't bring a claim of ordinary unfair dismissal. So you don't have that issue there. What you do need to think about is any breach of contract claim. Make sure you're following your contract when it comes to your own probationary procedure. But yes, you can extend one's probation. You can give them a try in another role and see if that role works. It's COVID, and they might move jobs completely. They might move from a sales role to a service role for that period. If that's something you wanted to go something that extreme as well. But yeah, as I said before, normal employment law rules apply. This person wouldn't be furloughed because they'd be employed and they'd be moved to another role. So it's as if really the job retention scheme wasn't there, and just the market had changed. And yes, you can move someone to another role like that, but bear in mind that that's going to be something that will be covered under their contract as well. Think about the contractual point as well, as part of the probation, about the probation extension, and whether you have the right to vary a role like that as well and move them around the business. Something just to consider, but that's going to be specific to the contract of the individual who we're talking about, the terms of that probationary period that's been agreed. Okay, Rob. Hi, Rob. I hope you're well. Rob and I have worked together before. So Rob's question is, I have employees who have a main job during the week and a weekend job with me. So just before we go on, 2 separate jobs. Can an employee be furloughed from 2 separate jobs? Yes, they can. Can I reduce their weekend hours and ask them to make up those hours during the week, which they claim they can't do due to their day job? Where do I stand? Really good question, Rob. I would expect that from you as well. So yes, if you have them employed for you over the weekend, you can say to them, forget the furlough scheme. They're still working for you. They're not on furlough. I assume they're not on furlough from their other employer as well. Yes, they can. You can ask them to say, well, I don't need you to work these hours. I need you to work now hours in the week for me as well. But bear in mind with that, what you're doing. That's a change to the contract. It's a change to terms and conditions. You need to go into an agreement with the employees about doing that, unless you've drafted contracts which give you a variation on working days clause. You might have that in there as well. But otherwise, no, you need to go and agree that with them, unless your contracts cover that. You might have a problem coming up from this, I would expect, asking them to work hours in the week. If they're already working those hours for somebody else, they might have to then pick or choose if they want to be employed by you or if they want to be employed by their other employer. But you can offer them that. Again, it depends on what your contract says. You might be in a difficult situation if they refuse that, and then you're saying, well, now I no longer need you. It may be that you've got a redundancy situation there because of the diminution in work or ending of the work that you need them to do at the weekends. But again, dependent on what the contract says. Thanks, Rob. Mary asking, can a director be furloughed and still operate the business? I covered this off before, but I'll just reiterate this really quickly, Mary. This is about the definition of work and what's seen to be work. There's very specific categories. Filing of accounts, providing information for administrators, that sits outside of what the definition of work is. But if that operation of the business simply generates any revenue or provides any service, then no, they don't fall under the job retention scheme, and they can't claim while they're furloughed. Okay, Jack. Question about redundancy. I've got quite a few questions about this last week as well. So, can you run a redundancy program while employees are on furlough? You mentioned it's a yes for layoff or short-time working, so I would imagine redundancy is the same. Yeah, redundancy is the same, but exactly as I said about layoff and short-time working, always think about whether you have that clause. You need the clause for layoff for short-time working as well in the contracts of employment, as long as it forms part of their contractual terms. So, can you run a redundancy program? Yes, you can. Can you make an employee redundant during this period? Yes, the same as you could do for failing employee's probation. It doesn't bar the right of an employer to dismiss an employee. It doesn't do that. So, in theory, and I've got a pretty important caveat to this advice though, but in theory, yes, you can go through a redundancy consultation. There's nothing stopping us doing that. We can dismiss employees. We can pay the employees their notice pay. And as long as we don't pay them in lieu of notice, we can claim that notice pay. This seems to be the generally approved position. We can recover that notice pay through the job retention scheme. There's nothing saying at the moment that we can't do that. But there's an important caveat to this. And this is, think about normal employment law that runs here. Normal employment law, when you're looking at a dismissal like this, and this would be, if a claim was to be brought about, this would be an ordinary unfair dismissal claim for redundancy. There's a test about reasonableness on that claim, that the reasonableness needs to be exercised by the employer in that situation. They need to have considered all suitable alternatives to that redundancy. Now, Jack, the problem we have at the moment is that is a suitable alternative to redundancy at the moment the job retention scheme in itself? Does that provide a suitable alternative? And if we made an employee redundant now, could it be found that in later cases that there was a suitable alternative at play at that point in time, which was the job retention scheme itself? And that's the difficulty. That's the thing that still needs testing. That's the thing we're going to find out how the courts take a view on that. We might get some further guidance on that. I would always caveat that advice about redundancy with, yes, there's nothing stopping us making redundancies in the country at the moment, but bear in mind that there's an alternative that wasn't there before, which is the job retention scheme. Simon, I think that covers off your question as well. But I'll talk about reduced demand in a second when I go on to the next part about coming back to work. I'll cover off the second part of that in a second. Okay, Tony, can staff use holiday whilst on furlough? And then Margaret, that's helpful. A question right next to it: can we make staff take holiday while on furlough? And then Isabel right next to that: is it reasonable to expect staff to take some annual leave while on furlough? Okay, so everybody wants to know about holiday. I'll answer all of these parts together. So there's another question as well there, which I don't think has been asked, but I'll just answer that one first. So question number one is, while an employee is on furlough, do they accrue annual leave? The answer to that is yes. Yes, they accrue annual leave while they're on furlough. That's the generally approved position, that they accrue annual leave while they were on furlough, because they're still employed for that period. And if they're still employed, they need their minimum annual leave entitlement for that year, 5.6 weeks. So they accrue leave. The second question is, can they take annual leave while they're on furlough? Again, the advice that we're providing and bear in mind, there's no real clarification on this point, but we think that yes, that employees can take annual leave while they're on furlough. And then the other question is, can we make staff? Or is it reasonable for them to do it? So, Isabel, reasonable, you could ask them. You can invite them to take leave if you wanted to while they were on furlough, and get them to use up some of their leave entitlement, because thinking about it operationally for a business, when we come back, which we think is going to be in a few weeks, when we come back, are we going to be in a position where people have got, some people, 5.6 weeks leave? Now, there is a new rule which has been brought out to say that they can roll that over for 2 years if it's not reasonable for them to take it within this calendar year. But what that doesn't cover us for is an employee just saying, I want to use my whole 5.6 weeks when I get back, and a massive people doing that when we could be coming back to much higher demand, to a much different way of working. So then it comes to the question of, can we make staff take leave while they're on furlough? Now, working time regulations gives us the ability as employers to force an employee to take annual leave. As long as you give them twice the notice of the leave they're going to take, you can force them to take leave. So as long as we give somebody 2 weeks notice to take 1 week of annual leave, that's okay under the working time regulations, and nothing in the guidance and nothing in the Treasury direction has said otherwise yet. So as it stands now, yes. The question's going to be, is in that period, is that akin to something different? And I think we're going to get further clarification on this. And this is the difficulty we have with advising on furlough, on the job retention scheme, that this came out quick. We've got guidance on it. We've got legislation. Some of it is contradictory. There are some omissions, but they're clarifying it as they move along. But this was something that's moved in quicker than anything else we've ever put in before. But when it comes to annual leave, is annual leave seen to be akin to something else, meaning that we can't force them onto it? But we think that working time regulation stands as it is. We have the ability to give them double the notice to put them on a period of leave. And I think that's reasonable. And I think what we're speaking to a lot of clients about at the moment is them not exhausting somebody's leave, but taking them to say, when they get to the end of June, if your annual leave year is January to December, when they get to the end of June, that we've either asked them to book in, or we've put into their calendars with double the notice of the leave, up to 50%. So we've used up pro rata what they would have used by that point in the year, sometimes a bit less, sometimes 40% by that point. So they've got a nice bit of time to take over Christmas as well if they want to. Hopefully that's covered off the question about annual leave. Okay, so question from Ben here. I think I've covered off that point, Ben, about accruing holiday during furlough. Yes. So Lewis, got a question here to say, got a new employee due to start next week, but I don't need them anymore due to COVID. What can I do? This is a really common thing that we're coming up against, that you've got businesses now who we're advising, and we advise across all industries. And those businesses, some of the bigger businesses, especially for more senior roles, have got people whose start dates were 6 months after they offered them the role. Some people on lower roles, the start dates might be a few weeks away. But everything's changed. A lot of them are thinking, for one, we're getting a lot of questions about redundancy. Are we going to come back and make people redundant? Are we going to come back and do layoff? Are we going to have short-time working? We're not going to be recruiting. We're going to be thinking about removing those vacancies. On the flip side of that, though, interestingly, we've got some other clients who are mass recruiting now, who orders are ramping up. They're filling up as fast as they can get people in, and we're giving them advice about how to get people back from furlough, how to make sure that the employees are agreeing, the employees are safe, that we're doing the right thing. So it depends on the industry, really, and depends on the business. But if you have a question about, I've got an employee who was due to start, and now we don't want them to start anymore, because not only are we not having any new starters, we're also thinking about reducing our current headcount anyway. What can I do? So think about this. Normal employment law rules apply. What if you had a new starter at any other time and they didn't start? Well, this goes back to, what does it say in the contract? They will have been provided with terms, they'll have been provided with an offer, contract. What does it say in that contract about notice pay? Because while the employee hasn't even started work for you yet, now, taking away any other claim that could be brought, which I'm sure isn't relevant here, is a discrimination claim, an automatic unfair dismissal claim, things like that, which don't have requisite service to bring the claim. You're looking at ordinary unfair dismissal. You need 2 years service. They're not going to have 2 years service because they haven't started. So that claim is one that isn't going to exist in this situation. But what you are going to have is a breach of contract. That's what you need to be mindful of. And the breach of contract, the contractual clause you need to be mindful of is the notice pay clause. So what does it say on notice pay? If it says that you have to give a certain amount of notice, then I would pay that notice in lieu to the employee, make a payment of them to this new starter. And that's what I would do to make sure I wasn't in breach of contract. But all of that depends on what it says within that notice clause and how much notice it gives them. But that's how I would deal with it. Okay, Caroline, what happens with staff members who've been furloughed but could not return to work because of childcare issues? Okay, so you've got a few options with this one. And I think this is something that we're going to see so much of that it depends upon when childcare opens up for whether or not people can come to work. There's a lot of people who, without childcare, can't work. So what happens to those individuals? So you could, as the job retention scheme currently runs, job retention scheme is running until the end of June. They could be furloughed until the end of June. That's fine. But what about after June? Well, as it stands now, the government are going to do one or two things, really. They've got an option to extend this scheme, give us more clarification on what's going to happen next. I'll cover that in a second. But what happens with those individuals? They can't return to work because of childcare issues. Well, if there was no job retention scheme in place, you'd be looking at what you could do to assist that employee, whether it's a flexible working request that you consider, whether it's a different way of working that's considered, and you'd have to deal with that situation as it came in. I mean, hopefully what will happen, because this is going to be a mass issue, that the government will give us a bit more information about this, and there'll be the job retention scheme and the ability to furlough an employee won't run out before we get into a situation where there's a mass need for childcare and people can't attend work. So I think that's what's likely to happen with that one. Okay, Lynn, this is a really good question. This is one, I gave the example before. Do you know about businesses that are doing really well, businesses that want people to come back to work now? This is the question we're getting a lot. So what happens if a staff member doesn't want to return, even though we've met the safety standards because they feel unsafe, or they have no childcare because of the school, nursery hasn't returned? So I think now is probably a good time, and I'll take this question with me into this part. It's a good time to move on for the last 15 minutes for me to discuss what is going to happen next, what the new landscape's going to look like, and I'll deal with this question as part of that, Lynn, if that's okay. So Sunday, we're going to get an announcement from the Prime Minister to say this is the phased plan of what's going to happen to get people back to work. It's going to be certain smaller shops first, things like that. Other countries have done this. Smaller shops first, smaller industries, then moving on to bigger and different types of industries. And the Chancellor is like to come out next week as well and give an announcement about how this ties in for us with the job retention scheme. I'll be covering this in detail on next week's session as well. But what does that mean? What do we think that's going to look like? So we've got a bit of an idea about how we think that's going to look, because there's been some comments which have been made over the last week. One comment that was made by the Health Secretary to say that it's not going to be a cliff edge, we're not going to fall off, and that we're going to be, Chancellor talking about being weaned off the scheme, which leads you to believe that as it stands at the moment, scheme covers the test that I talked about before, and some really good questions today about when somebody working, what can we do with training as well, which means that if they work an hour, you can't furlough them. That may change. That's something that I think may change next week. If we're talking about phase-based return to work, but this scheme needs to end at some point. It is costing billions. It needs to end at some point. But we can't. What's the point in putting the scheme in place if then they remove it before the COVID crisis is dealt with, and then we're going to have redundancies just being stayed for a few months rather than it helping phase the workforce back in, with the purpose of it was to avoid redundancies. So what's that going to look like when we come back? Well, there's a few things they could do now when we talk about being weaned off or not off a cliff edge. One, they could keep the scheme exactly the same as it is now and extend it for a further period of time, another 2 months, and take it to the full 6-month window. They could do that. I think that's unlikely with the language that's being used at the moment. So what are the other options? Well, they could reduce the 80% down to say 70 or 60% the government will cover. What if they do that? So what if that happens? What would an employer do in that situation? You would have to essentially, you wouldn't have to go back and re-furlough them because they're already furloughed. But the second part of that, where you had to agree with them to take 80% pay to avoid that unlawful deduction from wages claim, that breach of contract, you're going to have to go back to them again and say, okay, we agreed 80, the government are now doing 60, I need to now agree with you 60. You can't just keep them on the 80, you've got to go back to them again. They could do that, and other countries have given less than 80% as well as part of similar schemes. So that's what they could mean by not off a cliff edge, by weaning off. They could bring it down and bring it down from 80 to 60 to 50 to whatever they want to bring it to. That could be something. The other thing they could do, and there's quite a lot of groups who are lobbying for this. Personally, I quite like the thought of this as well, is that the rule on work is not as absolute as it is. So it means that what they're likely going to be talking about is you've got to balance the health and safety of not only everybody when they're in work, but also everyone getting to work as well. That's another thing that's key to think about. And that's a lot of things we're talking to businesses about. So I think what will be discussed will be staggered start times. So you might have a set of employees, you might have a range of employees, 10 employees who are coming back. And you have a couple starting at 8, 8:30, 9, 9:30, 10, 10:30. And then people leaving at 3, 3:30, 4, 4:35, and you stagger them throughout the day like that. So people don't work their full hours that they would have worked. They might not even work their full days a week. It might be that I do a similar job to another employee, and they decide that I'm going to come back and work a Monday, a Wednesday, and a Friday, and they're going to disinfect my area after that period, or we sit somewhere completely different. And then my co-worker who does the same job is going to come and work the alternate days, the Tuesday and the Thursday, and they're going to come in on those days. And we might switch that shift every week. So we do 3 days, 2 days, 3 days, 2 days. That's a possibility that we could do. And I think that we're going to get some guidance about that, because think about the strain on public transport. Let's put this into London. Let's think about the strain on the tube in the morning as well, how that's going to work. And that's something that they're going to be considering, I think, when they give out this guidance about how are we going to get back, how are employers going to get back to work. And what they might do is they might say, we're going to do that. So an employee works half of their hours a week, and the job retention scheme will top up, maybe not all of it, but some of it up to 80%. So they might say, you pay 50, we'll pay 30. And the employee still gets 80. We're starting to go through agreement with that. They still get 80, but where as a business taking 50% of that and the government are putting 30, that might be what they mean by weaning us off, by not off a cliff edge on it. That might be something we see next week. But what you've got to think about with all of this, and Lynn, I'm going to come to your question in a second, but what you've got to think about with all of this is, yes, what they're providing is got guidance to it. What they're providing talks about these changes of hours, but always remember that employment law always sits behind all of this. Employment law has not been completely washed away. Employment law is still there. And if you're going to change somebody's start time, if you're going to change how many hours they work a week, if you're going to change somebody's pay, you've got to agree that with them, unless you've got a clause in your contract which allows you to vary that without their agreement. If you don't have that clause, then you need to go into an agreement with that employee and get that agreement in writing that you're going to make that change to their contract. Don't fall into the trap of this, of thinking that the government's guidance is just, that's now means it supersedes it and we can just do that, we can follow that guidance, because the guidance is clear that says it doesn't replace employment law and does tell people to go and take legal advice, because some of this stuff is technical, especially when it gets to shorter hours, short time working, potential layoffs, maybe even redundancy situations. All of this stuff still sits in the same employment law framework that we had before. So that brings me to your question, Lynn. What happens if a staff member doesn't want to return, even though you've met the safety standards, because they feel unsafe or they have no childcare because the school nursery hasn't returned? Now, the school nursery point, I think I just covered that before. But if we move on to the because they feel unsafe part, and this is a question we are getting asked regularly at the moment. We're seeing this with quite a few clients who started having their employees return to work, and their employees have said, no, I don't want to come back yet. I don't feel safe coming back into work. What do we do then? What's our advice to that business? And this is a unique situation. These employees are not sick. They're not claiming to be sick. They're saying that I don't feel safe going out. I don't feel safe being exposed to this new virus. And we had this situation though a few weeks ago, that just before everybody went to furlough, before the Prime Minister put everybody on lockdown, that we had a situation where we had employees who themselves weren't ill, but they fell into clinically extremely vulnerable categories, or they live with someone who fell into that category, or they cared for someone directly who fell into that category. That employee was then something which was brand new, a new classification for us, which was something called shielding. That employee was shielding. So you've had employees, and some of them got told to shield for 12 weeks. Now, we're still within that 12-week period now. So, Lynn, if we're talking about a staff member might not want to return, let's check first about the status. So is that shielding employee? If they are shielding, then they attract SSP for that period. Now, there's a little bit of a mixed message on this, on the guidance and on the government direction, which says about whether or not you can move someone from that period of SSP and move them onto furlough. Now, quite a lot of employees have done this, but the government guidance says as long as it's for business reasons, you can move someone to SSP and you can put them on furlough. Again, same thing I spoke about before, agree it with the employee, agree the reduced rate of pay if you're going to pay, reduced rate of pay. But yes, you can do that, you can move that over. But the Treasury direction says something different. The Treasury direction says you've got to wait for that original period of SSP to end, then you can place them on furlough. Well, that means for a shielded employee, they've got to wait for the full 12 weeks of which they get SSP for, and then you can put them onto furlough and then claim under the job retention scheme for them. Both contradictory. And always bear in mind that the Treasury direction, if it can't be ironed out, will always prevail. That's the HMRC are bound to follow that. And this is something which is unclear in the guidance and needs clarifying for us as well. So that's the situation that you've got with shielding. But let's think first, okay, they're shielding. Now, I gave advice to a client this week where they were saying that they don't believe that the employees fall within the shielding categories. What can I do? So yes, if myself, I'm not in one of the vulnerable categories, but if I was to say my parents were in those categories, and this is what happened this week. So parents were in those categories. Well, can I just say then I don't feel safe coming in because I want to go and see my mum and I drop the shopping off for her? Well, only if I'm their direct carer, because otherwise, no, you wouldn't be going and seeing them. You could avoid them for that period of time. So it's about firstly classifying whether or not someone is shielding. So if they're shielding, they shield for the window, they attract SSP for that window. You can agree furlough with them if you follow the government guidance, but not under the Treasury direction. So you've got that option of furlough as well if you want to take the risk of going against the Treasury direction on that. But then what other options do you have? So what if the employee is not shielding? They just don't feel right coming back to work. I'm not in a vulnerable category. I don't care for anyone in a vulnerable category. I don't live with anyone in a vulnerable category. I just don't feel safe coming back to work and traveling into work at the moment. What do we do in that situation? And this is something brand new for us, but something that all employers are likely going to have to tackle over the next few weeks or so, sorry. So in that situation, let's revert back to normal employment law. So the employee is under a contract of employment. Contract of employment requires them to do a certain set of duties, usually at a certain location. If you feel comfortable, and I know that the question was caveated with this, that you've met the safety standards, you feel comfortable that you've done that, and we're following what the government are telling us to do, we've followed our requisite duty of care to these employees, you have work for them and work available, and you're asking them to come and do that work. Therefore, is that not a reasonable management instruction for you to ask them to do that? Now, all of this depends upon what's written within your contracts, what's written within your disciplinary policy. But in theory, you can then take that employee through a disciplinary policy, through a disciplinary procedure, because they're not willing to return to work. The same as if before all of this, if an employee just said, Lane, I just don't want to come to work today. Well, are you sick? No. Well, then I'm going to discipline you because you need to come to work. That's part of your contract, that you need to attend work on a day where work is open, where I have work for you. So we take them through a disciplinary process. Another option you could have is to agree a period of unpaid leave between both of you. And like I said before, you can't change something in a contract like that, but you can always agree something as long as both parties agree to it. It doesn't take you below the statutory minimum. So you could agree to a period of unpaid leave, or you could agree for them to stay on furlough for as long as you want them to stay on furlough for as well. If that's something the job retention scheme was still live and we're still achieving all the things we needed to do on that test. But that's a really good question, then, because I think that's a real situation that a lot of employers are going to be seeing over the next few weeks as well. And I think I've probably got time for one last question. Okay, Tony, this is a good question. Thanks for this. I missed this point on annual leave. Would we need to add 20% if they're taking annual leave if we're just claiming 80% furlough? Yes. So annual leave attracts 100% payment. So if you're going to have an employee on annual leave during a furlough period, then you would pay them 100% and you would claim back 80% under the job retention scheme. Okay, Hawk asking about assuming that the job retention scheme ends on the 30th of June, which is, we think it's going to end at the end of June at the moment. I think we'll get an announcement next week, though, about what's going to happen with this. I think we'll get more clarity next week. But do we need to start redundancy, layoff, short-time working procedures now? A lot of businesses are asking us this question at the moment. This is a thing that a lot of businesses are thinking about. Do we need to start this now? Because reading on the guidance, you have the ability to claim 80% of that redundancy pay notice period, not the redundancy pay in itself, any payment you make for redundancy, which falls within your contract or falls under statute for a statutory redundancy payment, but the actual notice pay. If they're going to be paid in lieu of notice, then the agreed position on that is that no, you can't make that claim, you can't cover a pay in lieu of notice for the reason that you don't know what's going to happen for that pay in lieu of notice period. You're going to make a payment up front, you don't know what the situation is going to be. But if they were to serve their notice, you could now, as you could with other notice period, there's nothing which restricts an employer from making a claim for 80% of that payment through the job retention scheme. So a lot of clients are asking us now, well, as we've now got the window to be able to do that, should we be doing that now? And the advice on this is similar to the one that I provided before a little bit earlier, that yes, there's nothing stopping employers going through redundancy situations. Of course, make sure you comply with all employment law legislation as it was before. None of that has changed. We still have rules around redundancy. We still have rules around the people who are selected for redundancy, for discrimination, for all of those different issues. You always need to bear them in mind, all very particular to the case that's being advised on at that time. But do we need to start thinking about it now? And I think that the other thing you need to balance that with is we need to think about whether or not it's going to come out later to say that, well, it was reasonable. There was a reasonable alternative to redundancy at the moment, which was in itself the job retention scheme. That was a reasonable alternative to redundancy. So we find that the dismissal in itself was unfair because there was a reasonable alternative. Now, how far those losses would go and where those losses will be capped at in a calculation of redundancy payment is a different thing. But this is uncharted territory. This is something that we've not seen before, we've not advised on before, and something that there are no cases to tell us how this is or isn't going to be seen or isn't going to work, and guidance on this. So in answer to your question, an employer's got a choice. They've got a choice, but they need to go into those choices knowing what risk each side of that carries as well. So we've got quite a few questions that I didn't get a chance to answer today. With those questions, what we'll do is we'll compile them, we'll put them into pools, and I'll deal with them the same way as I dealt with them at the beginning of this session next week. Now, if you've got any other questions, some people might not have felt comfortable putting a question in today. If you've got any other questions that you want to ask, if you can just send them through to an email address, COVID-19@Croner, CRONER, communications.co.uk. So that's COVID-19@CronerCommunications.co.uk. Send them over to us. We'll get back to you on those questions, or I'll add them in and I'll deal with them at the beginning of the next session as well. Next session is going to be at the same time, at 12 o'clock next Wednesday. And the next session is going to be focused on, we'll deal with the FAQs at the beginning that we've had that got sent in. Obviously, there'll be an open Q&A session as well. But I'll be focusing a lot more next week on what comes out on Sunday. And if we get anything from the Chancellor as well, what that guidance is, and a focus more upon how businesses are going to return to work as well. So thank you to everyone who's tuned in today, and look forward to seeing everybody next week. Bye.